Hello. My name is Brandon. Once again, live to you from our virtual studio here with Tactical Bra and Joe Tyson. And we're going to be covering the after hearing information that we get from Leonard in a few moments here. He's going to join us in a couple of moments. He's currently walking to his car from the courthouse. And so we are just filling time while we wait for him. Hello, hello, Tactical. How are you doing today?
I'm good. I'm so filled with anticipation. And naturally, as
it's
you were
exciting.
doing,
We've been waiting.
Yeah, as you were doing the countdown, I automatically had to burp really bad. I had to mute myself. I'm so excited I have to burp. It's
Oh, we have someone wants to join the meeting. There he is.
All right. How is everybody? Why am I buckling my seatbelt? I automatically do that when I get in the car.
Hello, we've actually just finished our introduction. Welcome, Leonard.
Excellent. I have just finished huffing it up 6 flights of stairs to get to my parking space. That was an amazing hearing and worth every ounce of effort that we put in for it. No, Richard Liebowitz is not in jail, but the judge definitely held him in complete contempt of court and everything. Said that he had... So actually there's a lot going on here. So we have the defense was the Bizarro defense. We'll get to that in a second. Someone tried to influence the judge. That happened.
What?
Liebowitz did not speak during his defense, but did give like a kind of post-closing statement, sort of a after the judge has ruled statement, which his attorney tried to tell him not to do. And I'll tell you why. So it was really interesting. I was right that the courtroom was more or less half packed. There were 22 people in the gallery of the courtroom, and it probably couldn't hold more than about 35 or 40 people if they squeezed together. The judge was in a good mood, and she was patient. She took the entire last hour and 10 minutes and just explained everything several times along the way, making sure to cross T's and dot I's everywhere along the way. Real quick, am I coming through okay before I get into the meat of it?
Yep, you're good. Apparently I'm not coming through okay, but...
Okay, so Liebowitz showed up with 2 attorneys. The attorneys did all the speaking for him. His main defense was that he was in some state of shock from his grandfather's death. He said he was, or his attorneys said that he was very close to his grandfather. They apparently submitted a letter and all the required documentation and everything yesterday, but the judge didn't want to put it on the docket until there was a chance to discuss redacting it. So that'll be on the docket like tomorrow. They were going to put it on today, but then they wanted to take time to make sure that social security numbers and addresses and things were redacted out of the death certificate and other documentation that he was submitting. But the judge was unpersuaded by any of it. She said that the death certificate clearly shows that the grandfather passed on April 9th, not April 12th. And so for Liebowitz to represent that the grandfather's passing needed urgent attention, it did not need urgent attention. He knew that any urgent attention it needed would have been needed back on April 9th, not April 12th. If there truly had been a week of mourning, because Richard Liebowitz purports to be a religious person, and everyone has the right to their religious belief. The judge gave this a lot of time and weight and said there's no problem that he needed a week of mourning or whatever. Should have called us, should have not doubled down on the lies, etc. The judge also pointed out that Liebowitz had submitted a letter to the court on April 9th, on the night of April 9th or something. And again, there was another one like a week later on April 15th or something. So if there truly was a week's worth of mourning, why were there 2 letters to the court during that time? Liebowitz said he's not supposed to touch cell phones and stuff during his mourning period or whatever. And the judge said, well, that's fine. You have associates. You have 16 people who work for you. So there's no excuse. There was absolutely no excuse. So she let his attorney go on and on and on for some time. The attorney had nothing substantive to say. Imagine hiring an attorney when it's clear that you've done something, when everybody saw it, everybody's got video, everybody's got evidence, everybody's discussed it already. Like, everybody knows you're guilty as heck, and then you hire an attorney to come in and try to assert your innocence. What's the attorney going to say? Well, don't believe the things you see and hear, believe what my client says. Or, as much as my client may have done something that caused some people to be upset, my client didn't do something so wrong as to warrant the punishment in this case. And then the one that really, I almost burst out laughing in the courtroom. After the judge pointed out how many times he doubled down, and even she got to, like, is it six? Is it the sextuple? Is it septuple? What comes after octuple? She asked. I think I asked the same question, so I thought that was funny. She asked, well, if the original date was just a mistake, and if Liebowitz really, just was mourning his grandfather's loss, why didn't he correct the mistake? And the attorney's answer was that, well, the fact that he didn't correct the mistake itself should be evidence of how much pain he was in, because it's just bizarre. He literally said the word bizarre. It's so bizarre that how could Richard Liebowitz have done this intentionally or on purpose? And this is while Richard Liebowitz is literally sitting right there, could answer the judge himself, but of course does not want to incriminate himself, so he does not say anything. So the judge finally says it. She says, look, he lied. I am convinced beyond a reasonable doubt that Richard Liebowitz lied to the court and then maintained the lie, and now is not saying anything because there is no exoneration from the lie. So she talked at him for the better part of that hour, because it was mostly her talking. His attorney got to say some things in the beginning, but then his attorney even admitted that there was nothing more to say, that all he's going to start doing is beating a dead horse, and that's going to annoy the judge and everybody. And why do that when the judge more or less already had her mind made up? So the judge started talking at Liebowitz, repeating herself a bunch of times, going over each and every one of the lies in detail. And she told him that he has a duty to the court, a duty of honesty. It's in Rule 11, which is the rule for when you sign papers. It's in Rule 3.3, duty of candor to the tribunal. And that honesty, or rather misbehavior that impacts honesty, is a quintessential reason for disciplining attorneys. And she mulled over for a while whether it was finally the incarceration threat that actually motivated him. She went over how the $100 a day fine did not motivate him, and the $500 a day fine didn't motivate him. And he seems to need lots of this sort of pressure. And so she had to make the incarceration threat to get him to show up to court. And it's at that time that I'm thinking maybe she's not going to throw him in jail. And indeed, she did not throw him in jail. But she did. She started equivocating as to whether or not she should throw him in jail for that. Instead, what she opted for was to hold him in contempt for the fine that we talked about, the $100 a day and the $500 a day. So that was good up until like yesterday when he finally turned in the papers. And she calculated his final fine to be $3,800, and he had turned in $3,700. And she said that was good enough, that she wouldn't normally just accept that. But, maybe there's just a miscalculation of a day, which day began the order, or whether yesterday counted or not. So $100, fine, sure, whatever. And she's not going to throw him in jail. But she did say that she has already referred him to the courthouse grievance committee. And so the grievance committee will figure out whether he is further sanctioned by the court, or whether he is sanctioned or disciplined by, or referred for discipline to the New York State Bar. And that was that. She talked at him for another moment. Then he said he wanted to speak. He said he was really sorry. And she said that she was unconvinced. And that was about it. Now, we had some other interesting things happen. But I guess I should pause for a moment to see if there's any questions or any comments before I keep going.
I think you should keep going.
Yeah,
okay.
I think you should absolutely keep going.
So I guess I'll just start from the beginning. I got to the courthouse, which is right over there. I think I can try to show you. Let's see if I can do this. Can't use Bixby while recording videos. Yes, thank goodness. So if I switch cameras, that's the courthouse over there, the tall building in the center. We were up in the top of that. The side on the left that's facing us is where we were. And it is still 28 degrees outside. It hasn't gotten any warmer. So I go over to the courthouse at about, what did I go about? 9 o'clock. And I'll adjust this. And federal court buildings are some of the most secure facilities in the country. I was not allowed to have my phone, even though I am a licensed attorney, even though I'm admitted to practice in Pennsylvania, in Northern New York, in Western New York. I'm not admitted to practice in Southern District, New York, which is this courthouse. So I was not allowed to have my phone. So I got to spend 2 hours without my phone, which is about as long as I ever spent without my phone in the past memorable amount of time. The security machine, the X-ray machine ate my belt, so they had to go get that for me. It fished out of the machine, and I forgot about it because they didn't realize it ate it first, and then I had to come back and get it. Belt's fine. I know everyone was worried. I was the first person in the courtroom, aside from the courtroom staff, and I was pretty much the only person there until about 9:45 when a whole bunch of people showed up. Like I said, it was about 22 people total. So we got 5-0 coming by here. Not for me, I hope. Okay. So the people in the courtroom were very quiet about Liebowitz. I did talk to the courtroom staff, and they knew who Liebowitz was and what was about to happen, but they did not know that he was infamous in a way. And I certainly didn't try to tell them anything more other than, yeah, he's been around a lot in these courts. So he's seen a couple of these hearings kind of thing. So then so eventually everyone comes in. Liebowitz comes in. Liebowitz is a medium build man. He's somewhat skinny. He was wearing a very nice looking blue suit with subtle pinstripes. He has that coif that you may have seen in pictures of him. He has a large black head of hair, or large head of black hair. No, it's a small head, but it's a large head of hair. I don't know how you say it. He's got a lot of hair on his head, and it's really wavy and shiny. And I think he uses hair product in it as opposed to hairspray. I had hairspray on this morning. He had hair product in his hair.
He has a glorious mane.
A glorious man coif, yes. Then his attorneys were bigger than him. He's only about 5'6", I guess. Not that it matters, but just to kind of describe, he's not an imposing figure. But he had two attorneys with him, one of whom did not speak, and the other attorney, Green, I forget, did all the speaking. And like I said, the attorney could not really articulate anything of substance. It was all basically, we're sorry we got caught kind of stuff. My client didn't mean to upset the court, was caught in the throes of grief, that kind of thing. And really, at some point, when you're saying things like that, especially someone who's a public speaker, an attorney, that kind of thing, they know that they're saying things that don't have a lot of merit, but that's all they've got to do. That's all they can do. In a sense, those are the easy cases because that's all I can do. I don't have to try and get the guy off the charges because you're not going to get the guy off the charges. So you just do your best to make sure they're represented. That's what I like about those kinds of cases where your client is guilty as heck. What I'm disappointed in is that the punishment isn't harsher for Liebowitz at this stage. Now, why wouldn't the punishment be harsher now? Well, the judge is a judge of the civil and criminal cases that come before her. And by the way, it's Sibel, not Seidel. It's Sibel. Judge Sibel is not a judge that really wants to be Richard Leibowitz's disciplinary committee. So she, instead of throwing him in jail herself, she refers the matter to the disciplinary committee. I think this is the disciplinary committee of the courthouse or the court system. This is the federal district court, which does not have the right to bar or disbar Richard Leibowitz in the state of New York. They could throw him out of her court system, like the district court, but she actually said she does not have the power to do that, nor is she inclined to do that. Instead, she held him in contempt, which means he'll have to answer questions about his contempt anytime he applies to another court system, either for permanent admission or for a pro hoc vice admission. He will probably be disciplined by the disciplinary committee at some point. We will see what happens there. Sometimes there are such things as private reprimands, which we don't see. Sometimes there are public reprimands, which are like slaps on the wrist, you know, a slap on the wrist or the back of your hand, because the discipline is warranted, but it's not warranted to have extra damage on your profession. Because when you have a reprimand on your record, that will show up on websites. It will show up on the state's website. It will show up on avo.com, avvo.com. They aggregate things like disciplinary complaints. So that'll show up on his record if he gets a disciplinary complaint that he is convicted of. He might get a disciplinary complaint and agree with it in order to avoid a hearing and a whole public trial or private trial on the disciplinary matter. Speaking of disciplinary matters, he said a couple things that might get him disciplined. He said that he had an associate of his file many of his filings in this case while he was in the grieving period, the quote-unquote grieving period. Well, the judge pointed out that he has had those things filed under his username and password with his signature on it. And that's actually not allowed unless he, in fact, has approved a lower level associate to do all of that. In fact, I don't mean ahead of time. I don't mean, yeah, Tactical, you can go file things for me. No. I mean, I need to review every single thing Tactical's about to file and give her express permission to file something. This is such a sacred thing that, in fact, I don't even file that many things, so I just do it myself. And Richard Leibowitz should have really been doing it himself, especially when it's under his own filing login. He's the one who has to answer for anything that happens under his own filing login. And I know of a case where someone used another attorney's filing login with permission and still got reprimanded. I believe they were suspended for a period of time. It might have just been a simple public reprimand. I expect Richard Leibowitz to get some kind of reprimand from all of this. There is just no way that he's allowed to lie to the court that many times and not get some kind of reprimand. So he's likely going to have a public reprimand. I would really like to see a short-term suspension, maybe a 1-month suspension, enough to really just sort of drive home that they can get to him and they can change his behavior. There was an attempt to influence the judge. This was weird. The very, very beginning, the court goes in, the judge, when I say the court, I mean the judge. The person says, the judge, the person says, I received a letter. I received 2 letters, one from opposing counsel, or one from Leibowitz's attorney. That's fine. That one's going to be on the record. That's no problem. But then the judge said she received an anonymous letter. Anonymous, she was going to respect the request for anonymity by redacting the email address, but not respect the request for anonymity in that the letter is going on the docket. So we're going to get to see the attempted influencing of the judge. But apparently someone anonymously emailed the judge a bunch of documents and links about Richard Leibowitz's prior court sanctions and behavior. The court acknowledged that they are aware of previous sanctions in the Southern District of New York, but otherwise They did not open the files to see the links or the documents. They disregarded the email once they realized what it was about, that it was an ex parte, or not even ex parte, but an attempted letter to the judge in violation of law. Like you're not allowed to do that. That has to go on the docket, and the parties have to have a chance to argue over it. And it has to have been submitted by someone who had permission. So if you want to submit something like an amicus brief, you have to enter your appearance and make the motion for permission to enter an amicus brief, which was not done. So that letter is going to go on the docket, and we'll all get to see what that's about. I imagine that will be on the docket later today or sometime tomorrow.
An enemy of the court.
An enemy of the court. Yeah, not a friend of the court, an enemy of the court. Yeah, exactly. So yeah, that's what happened. That's the end of the hearing. We were all pretty much ready to leave by the time that the court dismissed. It is very cold outside, and there is no place inside the courtroom to interview Richard Liebowitz, or inside the courthouse. So I didn't even try to get an interview with Richard Liebowitz, let alone that I don't know what I'm going to ask him. Hi, Richard, how do you feel about all of this? Do you think this was a good idea? Would you like to further incriminate yourself on my show? I just didn't see that 28-degree weather on the courthouse steps was the right time to ask those questions, let alone he had 2 attorneys, and they were pretty good about not letting him answer questions in the courtroom. He really wanted to speak on his own behalf, I think, but he didn't have anything that he was going to be able to offer, unless the truth was actually that he messed up and didn't mean to lie all these times. There was really no way that he was going to talk his way out of it. So even his little speech at the end, where he said he was really sorry and his head was spinning from all the grief of his grandfather dying and everything, that didn't buy anything with the judge, and probably even helped incriminate him a little bit more for the inevitable disciplinary proceeding. So where is he coming from? I think maybe he is a former and possibly current photographer who thinks he's smart enough to get a law license, pass the bar. He did, but he is not coming from a place of legal education. I'm not either, by the way, if you can't tell. But maybe he's not coming from a place of legal legacy and legal education and everything. Maybe he's coming from a misperception of lawyers as buckaroos, as cowboys, and that we can just do whatever we want until the court says otherwise. And that's not quite how that works. 2 more things. So Richard Liebowitz was fined $3,700 out of his $3,800. He was held in contempt, but the contempt is considered satisfied, but there's still more. He is going to submit himself for what I can only imagine and speculate is psychological counseling. They described a professional who would be helping him, and he would talk to them. So it was all very coded word for he's gonna seek professional therapy. Second, he has to seek professional therapy. Reversed. So in the first one, he has to seek therapy from a professional. In the second one, he has to seek professional therapy for his business. Like, the judge wants him to seek help from a law practice professional who will help him learn to run his law practice in an ethical way without running afoul of the law. Ooh. So that's an opportunity for someone like my friend Micah Ascano to come in and teach him Six Sigma about error checking and redundancy. Tactical and I use these same sort of systems where you simply implement policies and procedures that you never violate, that you always put a certain number of checks and balances in place, and that makes sure that you can't make a mistake. Because I've checked the bank account, I've checked the ledger, I've checked the client file, I've verified that Heather agrees, and she's verified that I agree, and we all checked it. And then when we check it 5 or 6 times, then we know that we can't have made a mistake. So Richard Liebowitz needs to implement policies and procedures so that he doesn't make those kinds of mistakes.
I actually really like that because I think one of the concerns that I had was that it wasn't that he was incompetent as a lawyer, and it wasn't that he didn't know his stuff, and it wasn't that he was representing people who did not have a legitimate claim. It was just the sheer volume of cases made those errors more frequent. And I think, having a consultant brought in to teach him about his ethical responsibilities in order to reduce those errors, I think is a very measured response. And I think that adequately addresses the issue.
Hang on just one sec. I am typing in my address to go home. And now
You're
that I'm
good.
done with the major dramatic part.
Yeah, can I start reading you super chats because we have many?
Yes, please.
Okay. Let me start from the very beginning. A very good place to start. All right. So from Hastur, we have $2 saying better this than the public impeachment hearings that started approximately an hour ago while we were waiting for you to come back there, Leonard.
Okay.
We have Q Squared donated $2 and said thanks for going to court on our behalfs.
Yay.
Mike
You're
Baker donated 240 yen using free super chat to help cover gas money. Michael
Yay.
Wade, more free money, $5. Mike Loggy donated $2 and said this judge gets paid too little dealing with this.
Yeah, right. Oh, that's the exit? Okay.
Dine Online says donated $2 and says, are there a bunch of people covering this in the room? Did you see a lot of people that you would have pegged as reporters, Leonard?
There were a couple reporters and there were a couple lawyers. Everyone seemed to be very much interested in the fun of the case, and I didn't see more than like one person reporting on it, like writing stuff down. More so, everybody was just like typing. Well, the one woman was on her phone. She was obviously a reporter. She was on her phone the whole time, but she was a clerk. She worked for the courthouse. She got off at the 5th floor, so she was either an authorized reporter for the clerk or for the court, or she was actually a clerk, like a court clerk or a deputy of some kind.
Ah, okay.
Meanwhile, I'm trying to figure my way out of the world's maziest parking garage.
Someone in chat just yelled, "Don't stream and drive," and I had to reassure them that I am the one streaming and you are completely hands-free.
He is streaming. I am completely hands-free. I'm not even going to be looking at you any long.
Oh, Leonard is in the bottom.
And I'm not. I don't even. I have my
garage, so he may be a bit choppy here. We're losing you, so just give us a second here.
Oh yeah, you want me to switch over to audio? I can switch over to audio only if you want.
Well, you should be out of the building in a moment here. I think the problem we were having with Discord video before was actually Discord and not your connection. So let's just give it a minute here.
Hangouts did a.
So for people, this is what we have to deal with on a pretty regular basis with Leonard. Occasionally his Discord just does this to us. And we have to deal with that. We can see you again, Leonard, so I assume we can hear you again.
Oh, good. I'm having to go around the entire parking garage to get to the spiral to go down. Oh, like so you have to go through the entire garage. There we go.
Arma Akana donated $2 and said, "Woohoo, free super chat." Lots of, I don't know if like YouTube's doing a special promotion or something, but there seems to be a lot of free super chats going on. Beanbag 109 says, "You guys rock." Sean Dugan said, "Free super chat squad." Majestic Barrel said, "Free super chat. Use them, people. First time catching live. Liebowitz was being spoon-fed crow and told to either eat or go timeout. How'd it go?" And I think we mostly went over how it went, but yeah.
Like, yeah, he was spoon-fed crow mostly.
Yeah.
Like the judge was like, "I really don't want to do this to you, but you're making it impossible for me not to."
Yeah, for reals. Elephants in the Forest donated.
Bike share. Is that Bird? Which bike share is that? I'll call it out when I go past.
Elephants in the Forest donated $2 Australian and said, "Great work. Thanks for going the extra mile."
You're welcome.
Phantom
Thanks
Fred.
for all of you for waiting around. You waited around for a long time to find out what's going on.
Yeah.
It is a lime scooter or a lime bike.
It went so long that the three of us had agreed that we were about to go live when Leonard messaged us. We were like, okay.
Agreed to go live anyway. Ain't funny.
Yeah. We were like, okay, it's time to do some kind of a pre-stream or something, so that we stopped resetting the timer.
287.
I was wondering if we could talk a little bit about being referred to these disciplinary boards, because I think that there are a lot of consequences that can come out of that. Can you talk about the process a little bit, and then I'll ask my complicated hypothetical?
Sure. It is the same due process that is due to a criminal defendant. The disciplinary board, however, is not a jury, is not a judge. It is a board of other lawyers who are appointed or hired to sit on the disciplinary board. Let's see, 287. Hang on, I gotta get in the correct lane. So it's I forget how many people are on the board. It can vary from state to state. I don't imagine it's always the same number of people. But a disciplinary complaint is made to your bar. The bar, when they say raising the bar and all that, that's the state bar. That is the bar exam. That is the lawyer bar. If you have passed the bar, you are a licensed attorney. So a complaint is made, and it just has to be like a complaint in writing, and then they'll conduct an investigation. I don't mean a complaint as in like a lawsuit is a complaint. I mean a complaint as in like someone writes out what their problem with you is. That's that kind of complaint.
And it's mostly in private, correct? So this will be mostly behind closed doors.
And this is all in private at this point. The complainant could decide to make it public, but the bar does not make it public yet. The bar, in fact, doesn't want to make anything public until they are sure that you are convicted, until they're sure that you are guilty. Oh shit! Do I want west? I want west. Yeah, Tappan Zee Bridge west.
So what was your hypothetical, though, Tactical?
Yeah, so one of the things that crosses my mind is that the disciplinary board is going to do an investigation. So they're going to review things thoroughly. Yes. One of the concerns that I have in my mind, and this is hypothetical because we don't have this information in the public, but we know that the case settled quite quickly after he missed that conference.
Yes.
And so
the judge noticed that too.
Yeah. One of my worries is that he stopped acting as a fiduciary for his client and instead looked out for himself. So if he had told
that's a really good one.
If he had told his client, like, let's hold out for a $2,000 settlement or whatever, made the mistake, didn't want to be under the judge's purview anymore, and then said, okay, let's accept their $500 offer, he could have been doing that for his own benefit instead of his client's benefit.
Yeah. Yep. Well, that sounds like a breach of the fiduciary duty as well. You're absolutely right.
The way the judge phrased their letter, though, that discussed the settlement, it sounded like actually the plaintiff had paid the defendant. It sounded like the plaintiff had settled with the defendant and paid them. I don't know if that's not what happened, but
there's no way to know. The settlement would be confidential, and there's probably no way to know.
Yeah, it sounded like that was what the language said. So that's what I noticed.
All right, and for anyone who's concerned about the driving, I am just sitting at 60 miles an hour here behind a truck, just cruising along.
And doing nothing else but driving and talking.
We're not doing anything weird. We're not. Oh, there's like smudges on my lens.
And now we're doing something weird.
Now we hit traffic, and now we completely. So we're going to even be stopped.
Lovely.
Why is there? Oh, is it bridge traffic? I guess it's bridge traffic.
I'm just gonna few more super chats to go through here.
Sure.
People were donating.
Oh, it's people getting off at Elmsford, Route 9.
So, okay. Andrew D asks, any professional media presence? I think they're referring to you, but I'm not 100% sure. Like, do you? I
Oh,
guess do
waste
you have
crush.
any professional media presence? Is what he's asking.
No, I don't know what you mean. Were there any professional media at the courtroom?
At the courtroom,
Not
yeah.
that I know of. They don't advertise themselves like that. Where am I getting off? Exit 15287. Okay.
So like no Channel 69 T-shirts, that kind of thing.
No, nobody in like media outfits. Anybody who was there from the media was dressed in a suit and tie or whatever's appropriate for women, and nobody like let it be known that they're from the newspaper or whatever.
Yeah.
It was radio silence on Twitter the entire time.
Yeah, it definitely was. We might have actually been the first people to report on this.
Yeah.
Noah Palmer donated $5 and said, "You should do more of these. This was fun."
Yes, we would love to do more of these. The problem is that I don't live near all of these. This is the closest one so far, and this has been a 2-hour trip. Well, a 3-hour trip there, and it should be a 2-hour trip back, I hope.
Yeah. Mike Loggy donated $10 and said, "More gas money. Love you guys, and thanks for everything you guys do."
Thank you so much. Really appreciate it. This is really helping us out, guys. And yeah, Lawful Masses is not a static organization. We intend to grow and learn as the people that run it grow and learn. So the more resources we have, including money, but also including community participation, including submitted stories, including audience attention, how excited you guys get for stories and stuff, it's going to grow as big as it can. I'm trying to adjust everything I need to adjust in my life to make everything possible for Lawful Masses, while also still being able to be with Kaylee and all that. So we might even have Lawful Masses in Luxembourg or something at some point, because I'll be over in Luxembourg with Kaylee. It's, living there at some point, I hope. Oh, that's a beautiful bridge, the Tappan Zee Bridge. Wish I could show you, but I cannot. Take too much effort to play with my phone. But
So
go look up the Tappan Zee Bridge. Tappanzee, Tappan Zee Bridge.
So the last donation I have here that I'm going to read is somebody. We have been streaming for about 40 minutes. There are some newcomers. Do you want to just do like a really fast summary of what happened for them?
I will not do a really fast summary. Let's do a whole summary, because it's really dramatic what happened.
Okay.
So I woke up really early this morning, and I drove all the way to White Plains, New York from eastern Pennsylvania, which is like a 2-hour drive, but then it's 3 hours because people are stupid in traffic. And I even almost had a car accident because somebody brake checked me, but my brakes work. Because you guys have paid us enough money that I was able to get my car fixed last year. Now I also contribute and everything with my law firm money and all that. But between the two of us, we've got this thing going. Everything's good. So we were there for the dramatic hearing of Richard Liebowitz, who is a copyright troll. He has been called a copyright troll by other judges 6 or 7 times around the country, including about 6 times in the Southern District of New York, right here alone. Although I guess, am I crossing into New Jersey now? I guess I'm crossing into New Jersey now, yeah. So Richard Liebowitz is a copyright troll. What does that mean? That means that he files copyright lawsuits on behalf of his clients. So yes, I agree with him that makes him less trolly. It's his clients that are trolly, but he's the one that's enabling them. So he files these copyright lawsuits on behalf of his clients. Is that copyright trolling? No. No, you're allowed to file copyright lawsuits on behalf of your clients, and I totally understand why you would do that, because copyright does need to be enforced for you to, make money off your copyrights, basically. But it's how he goes about it. It's that he files. Oh, that was something hard that just hit my car. It's how he's filing these lawsuits. A copyright lawsuit should be used to enforce copyrights. It can be used to make money off of that enforcement of that copyright, but it shouldn't be the primary purpose. And you shouldn't really be going after more money than you're due. So even if you're due punitive damages, you shouldn't be getting more than that. Now, Richard Liebowitz is the kind of plaintiff's attorney that files lawsuits over $10 or $20 in damages and demands $5,000 in payments. That's one of the reasons we call him a copyright troll. We call him a copyright troll because of stuff like today, where instead of accepting a reasonable amount of money, which I believe was $2,500 in settlement or something, he instead demanded the $5,000 and lied to the opposing counsel about how much evidence he had to support the $5,000 figure. When it was finally revealed that that he had nothing, it was already after this whole thing had taken place, and I believe the case had been settled then. So that's why we call him a copyright troll. This is not the only kind of thing that he does. In California, I was telling you before, he basically filed documents that in effect enter his appearance, and then he did not enter his appearance on time, and the judge threw him out of court, literally disbarred him from the Northern District of California court system because he did not file his entry of appearance at all, really. He said he was going to, but that wasn't how the procedure was laid out. So today he was there because he had told the judge that his grandfather had died, and that was why he missed a court hearing. Like, just completely missed a court hearing, didn't call, didn't write, didn't apologize initially at first, like with an effective description of how he made the mistake. Instead, he kept telling the judge bigger and bigger lies, that the grandfather had died on April 12th and that he had to respond to the urgent matter, that the grandfather had been buried the same day that he had died, etc. Well, it turns out the grandfather was buried the same day he died, but that day was April 9th, not April 12th. April 12th was the hearing that he missed, so there's no excuse. There's no excuse for not notifying the court. At least you could tell the court and opposing counsel that you missed the hearing and you're sorry. Instead, it appears he had no remorse or no concern, was the word the judge used for the lie. So he continued the lie. He said that he didn't believe the judge had any right to ask for the death certificate. He said that the death certificate was private. And then when the judge said that you could submit the death certificate to the judge privately, that was still not good enough. The judge questioned whether, or Liebowitz questioned whether or not the judge had the authority to hold him in contempt or ask for a death certificate. And he just maintained all of that. And then he didn't pay his sanctions. When the judge fined him $100 a day, he didn't pay it. And he kept asking the court to defer it. And today he asked the judge to vacate it, to just dismiss it, eliminate it, as if it never happened. And the judge just wasn't having any of that. So he asks the judge for all of this, and the judge gives his attorney a chance to explain. And the attorney doesn't have much of an explanation. Really, the best explanation the attorney had was that the poor guy's grandfather had died, and it was a big emotional mess for him, and he's really sorry. But he didn't have any explanation whatsoever as to why it took so long to fess up to the mistake, or why the mistake went uncorrected for so long, or why Liebowitz doesn't appear to want to provide the documents for 6 or 7 months. So the attorney then made the most bizarre argument I've heard in a while, which was literally that Leibowitz's behavior is so bizarre that all by itself, the bizarre behavior is evidence that he was in the throes of grief and couldn't respond to the judge's complaint or judge's request properly, and didn't really know right from wrong.
Nobody in their right mind would do what he did, therefore he was not in his right mind?
Exactly. So the judge didn't buy it, said that That's psychosis, basically. And there's zero evidence in the record that Richard Liebowitz suffers from any form of psychosis. Like, an inability to know right from wrong, even temporarily, is not something that was ever submitted to the court or the record. So that's just out, right out. And the judge then went on for basically 45 minutes to explain everything that I just said, explain why honesty to the court is necessary, why you can't just lie to the court and then double down and triple, etc., all the way to like the 8th or 9th time of lying to the court, why you can't just do that and get away with it. So the judge had fined him a total of $3,800, of which he had paid $3,700 yesterday, even though it was due a long time ago. So the judge didn't fine him extra on top of the fine, and she didn't jail him on top of the fine and the other stuff, but she is going to refer him, or she already did refer him, to the disciplinary committee or the grievance committee of the court. And that was it. She gave him a chance to speak. He had the chance the whole time to speak, but his attorney was pretty good at keeping him from speaking. But then at the end, Liebowitz really wanted to speak. And so Liebowitz said that he was very sorry and that his head was spinning from the whole grieving over his deceased grandfather thing, and that he's sorry and it will never happen again, and he's really sorry. And did he say he was sorry? So that was the essence of Richard Leibowitz's response, is that he's sorry. Or at least he says so. And that's about it.
I think, once you make the mistake and you're sorry for the mistake, you can fess up to the mistake and say, I'm sorry. But I think the months of cover-up kind of makes it seem more like he's sorry for getting caught rather than for doing the thing. Yeah. Here's how go ahead, Brandon, and then I'm going to tell you how I think it went.
No, you tell me how you would think it went. I have a lot of super chats to read, so I'm going to let you finish your story first.
Well, I was thinking of how Richard, what actually happened. I wanted to try and speculate what actually happened. I think that Richard Liebowitz got himself really overwhelmed with a number of cases. It turns out there's a whole freaking gold mine out there of unprosecuted copyright actions. So he just has to go to photographers' conventions and talk to them about how copyright can protect their photographic works. And then he offers to protect their photographic works himself. And he's found a gold mine. He literally stumbled upon Blackbeard's ship full of gold. But then North Carolina comes along, metaphorically speaking, and says, wait a second, we own some of those rights. In Leibowitz's case, North Carolina was his duty of competency, came along and said, hey, by the way, you can't file this many cases unless you can actually keep this many cases going. And so along the way, he started to have trouble keeping this many cases going. So he's learned, as many of us have, how to make excuses. I learned very quickly how to tell lies and make excuses when I was a kid, because that was the only way I was gonna survive. Like, my parents were really strict, and if I wanted to basically get away with anything at all, and I don't mean super dangerous stuff or super illegal stuff, I just mean existing as a human being, I was gonna have to learn to lie, and I'm pretty sure he got pretty good at lying, or at least making up excuses. And he's probably made these kinds of excuses before, and after a couple inquiries, somebody just gets tired of it and forgets about it. I mean, I woke up this morning and I had half a mind not to even do this, even after I said I was going to do it. I was like, oh God, I'm tired. It's cold outside. It's really cold outside and I'm tired. Oh, that's really easy for me. I'll just stay in bed. Yeah, so it's really easy for him. He's going to tell a little lie. He's just going to tell a fib. It works. Who cares? The judge isn't going to care. He doesn't take his duties that seriously, and the judge doesn't take duties that seriously anyway. Whatever. He's dismissed the case. It's going to be over. So he just made up a quick lie. Oh, yeah, my grandfather died. I'm real sorry. I'm not even going to say, my grandfather died this morning and I have to take care of things urgently that happened today on April 12th at 8:30 a.m. No, he just says, my grandfather died. It's been weighing on me. I'm really sorry. It's urgent. I missed the thing. I'm sorry. He doesn't really give all the facts because frankly, that's how lawyers get away with stuff, is we tell only the facts that are good for us, and we leave out the facts that aren't. And if you don't notice, good for us. So he thinks he's got away with it. And then the judge just decides to start looking. It's just like, hey, this doesn't sound right. Just show me the death certificate. Well, now there's no death certificate, because if he shows the death certificate, then now she knows that he lied. And worse than that, he can't even say it was a mistake, because a mistake of that magnitude, the judge isn't going to believe that either. He's already doubled down on the lie. He's already said, oh yeah, it did weigh heavily on me, whatever. An urgent matter. So he's doubled down on the mistake. He can't correct the mistake without also admitting that he lied and basically getting a grievance against him, a disciplinary action. So he takes his chances in hopes that the judge will just drop it after the second or third time of stonewalling. I'm sure he thought that the judge would drop it after the first request. I'm sure that he didn't even think the judge was going to ask about it the first time. And so the second time, he was already too late. It was already too late the second time, because he didn't think his lie through. He didn't think, how am I going to suborn this lie or support this lie if I don't do it the right way. So he didn't think about that. He thought the judge would just buy it. And so he didn't think about step 2 of what happens when she questions it. So he then just has to keep doubling down, because there's nothing else he can do. He might have even talked to an ethics committee attorney who might have even said, well, there's nothing you can do now. You might as well just keep doubling down. Or he might have not, and he might have not talked to any attorneys until just a few days ago, or just a few weeks ago, when he got the contempt order from November 1st, 2 weeks ago. So he has to just keep doubling down, tripling down. He has to keep telling the same lie over and over again. He has to keep delaying, so the judge never gets the death certificate until it's too late. Now he is being threatened with incarceration. Now he has to tell the truth. Or wait, no, he doesn't. It's a threat of incarceration. You don't have to help someone incarcerate you in the United States. You have a Fifth Amendment duty or right not to self-incriminate. So he has the right, and even the judge acknowledged this, to not speak in his own defense. So he doesn't even have to explain himself. The judge has to make the case against him. And so the judge does. The judge makes the case, and the judge decides to be a little bit lenient. The judge could have ordered further incarceration, but the judge doesn't. Further incarceration isn't necessary anymore. Incarceration isn't going to compel his conduct, his compliance with the court order to produce the death certificate. He's already produced the death certificate. Now we can leave it to someone else. It is the disciplinaries committee. It is their job to decide what discipline is proper for him. So she fined him $3,700. That's pretty good for discipline already. He's going to have a contempt finding on record. That's pretty good already. And there's really no other reason to throw him in jail. So she didn't throw him in jail. She's just going to refer it to the grievance committee, who will then refer it to whichever disciplinary committee they find appropriate. Or they'll disbar his admission to the Southern District of New York. This is a membership of sorts. He is an officer of a particular court system, and he could be disbarred from the Southern District of New York separately from the state of New York. And for example, a couple weeks ago, he was disbarred from the Northern District of California, where he was never admitted. But at least now he can say that he's been disbarred from the Northern District of California. Well, now the Southern District of New York, the Southern District of New York could decide to disbar him here. And that would be separate from his New York State Bar membership. And then the state bar could decide to disbar him as well. Sometimes these things have a knock-on effect. And if you're disbarred, I believe you have to report it to your currently barred bars. And I believe the Northern District of New York has done that as well. So Liebowitz is on the short bus. No, he's on the short ride to disbarment. Is basically where we are. I expect him to be disciplined at least.
Yeah, it's really rough for him, man. But he shouldn't have lied.
shouldn't have lied. I don't understand the propensity to lie. There was nothing gained by that lie. He could have simply said, I messed up, I'm sorry, and the lie would have been taken care of. Like, there would have been no need to lie anymore. The situation would have been taken care of. So it baffles me to the extent that, yes, a sane person would not have done this, so he must be insane. That's where my brain is going, but not like to the level of insanity that exonerates him. More like the level of insanity like that we just stare wide-eyed at while eating our popcorn and drinking our fizzy drinks, our fizzy lifting drinks.
It's the type of thing that makes you wonder if a competent lawyer would act that way, which is a question for the disciplinary board.
Yeah, so that's Rule 1.1, not competent. Rule 3.3, lack of candor and honesty to the tribunal. Probably whichever rule is about the fiduciary duty to your client. It's in Rule 1 someplace, not Rule 1.1, it's like 1.2 or 1.3 or something. Maybe it is in the duty of competency. It could be there. So, yeah, that happened. That's remarkable. And I guess, Brandon, go read some super chats.
All right, I'm going to try to quick fire these. Phantom Frag donated $5 saying, thank you very much, Leonard, for taking the time to go upstate in the cold to see the show. Hello from Chicagoland.
Hello. To Chicago.
The seventh Circuit. Daniel Zawadzki said, donated $2 and said, don't pay attention to the man behind the curtain.
Yeah.
A Cool Pool donated $5 and said, free super chat.
Yay.
Stephen Romerman donated $2 and said, if you have to eat crow, ...
Eat crow while it's young and tender, or surely you will eat it while it's old and tough.
Well,
and he has waited until this is the stalest, oldest, smelliest, toughest crow I've ever seen.
Yeah.
We might need to make a t-shirt with that on it.
Yeah.
Yeah, I think we need to make some t-shirts. Dan the Affordable Moving Man.
Nathan Arndt donated $20. Asked for a summary, we just gave that to them, but thank you so much for the $20.
Thank you. I think that will be the only other summary. So we got 2 summaries, and you have to go back and watch the video if you want to see the more summaries.
Yeah. Public Void Marnold donated $5 saying, how will this affect his future prospects? Like, will he have to tell other judges what happened?
He will not have to tell judges to courts that he's already admitted to, but those admissions might be taken away, and he might have to re-seek them. This will appear, any disciplinary action that he is convicted of or agrees or pleads guilty to will be stuck on his record. Other people may be able to find this on his record then when they go to search for, is my lawyer competent and all that stuff.
And the news coverage probably doesn't make potential clients really want to engage him.
Right. On the other hand, this kind of news coverage shows that he's one of the only attorneys who's willing to go this far for his client.
That is the most generous interpretation of the situation.
Yeah.
I mean, if his client was himself.
Yeah, he went this far for himself, not for his client. That's the sad part. He had a good thing going. Maybe he'll be okay. I'm assuming he'll be okay. This kind of thing will blow over, and he'll be representing plaintiffs' attorneys again already. And even if he gets suspended, I don't know that he'll be completely disbarred. Even like we've seen some attorneys do some really egregious stuff and only get a 1 or 3 year suspension. Even if he got that, he could still go back to practicing law after that. Doing this kind of thing. So he's still got it made, I think. Not that I like that, but he's still doing fine if he just stops, if he just doesn't mess up like this again and again and again and again. I think he's still going to be okay. He just might have he might have to return to being a photographer for a little while. That might be what happens to Richard Liebowitz.
Yeah. Paula Madeline donated $5 and for toll money.
Oh, thank you.
Kidstock TV donated $10 for gas money. Be safe and thank you, he says.
Thank you very much. Appreciate it. Appreciate all your donations.
Andrew D donated £5 and said, do you think that the Chewbacca defense would have been a valuable strategy here?
I think that's what they tried, basically, but they didn't do a very good job of it. So I think it wasn't a pure Chewbacca defense, but it was a bizarro defense. It was, my client's behavior is so insane. Look how insane he must have been. Please consider how insane he must have been to act like this. That was the bizarro defense in my mind. The effectively a Chewbacca defense, trying to not confuse the court, but be like, come on, Your Honor. This guy's a competent attorney. We all know it. He just got crazy for a little bit here. We're sorry. He's not going to get crazy again. We can't explain why he got crazy or how we know that he's not going to be crazy again and lie to the court, like while he's in this crazy state. But, it just happened to him. So we're sorry. I can't wait to use that defense at my trial. There won't be a Leonard French trial. I haven't done anything wrong. I'm not guilty.
John Gingras donated $5 and said he was playing a game of chicken with the court, but he was on a tricycle and the judge was driving a semi.
Yeah. Yeah, I often play the game of standing on the railroad tracks and holding up your hand and seeing if the train will stop. But it is a very risky game, and you'd better damn well know, who's driving that train or when they're going to stop or whatever, because if you don't, you're going to get run over. And that's what happened to him today. That train, at least the train put its brakes on so it didn't hit him as hard. The judge was nice. The judge was nice to Richard Liebowitz. I wonder if the judge would have been as nice if there was like an opposing party who was there complaining, as opposed to he just lied to the court.
Oh, if someone besides her was affected, I think he'd be in jail. Like that's
She
terrible.
did point out that he was lying to opposing counsel to try and gain an advantage in the case too.
I mean, in one of her her requests for the certificate, she said that the only reason that she called out the grandfather being dead was because he was lying about the evidence that he had. He said, well, that kind of speaks to your character, and now I'm wondering if their grandfather even died.
Yeah.
There are a couple questions here about the Chewbacca defense, and so I just wanted to try to summarize it, and you can correct me if I'm wrong, but it comes from an episode of South Park, I think, and
yes.
Basically,
which comes from the O.J. Simpson trial. Like the Chewbacca defense was really tried, but it wasn't literally Chewbacca. It was a confusing defense that we call the Chewbacca defense, named after South Park's using Chewbacca to describe how confusing it was.
So basically the defense strategy is to throw out so many facts at once and try to make sort of a connection between this mess of facts, saying it's like, well, if A is correct and B is correct, then there's no way C could have happened. But the connection between the facts is actually quite tenuous, and the conclusion that comes out of this smattering of arguments is not necessarily not guilty.
Pretty much non-existent.
Yeah,
pretty
but
much non-existent.
Overwhelmed the jury with everything that they get caught up and lost in everything that's just been said to them, and they get convinced by not understanding the situation, essentially.
Yeah. It's sort of the bizarro defense using the lawyer. Like the lawyer gets up and says a bunch of bizarre stuff, and the jury is like, well, that famous expensive lawyer wouldn't have said all that stuff if it didn't mean something. And so this comes from the Johnny Cochran presentation at the O.J. Simpson trial. who attempted to confuse the jury with where OJ was and where Nicole Brown Simpson was, and whether the gloves fit. If the gloves do not fit, you must acquit, was the famous line. He tried to make it appear that the gloves were too small, even though the gloves did appear to be the right size. They were definitely form-fitting gloves, but they did fit properly. But they tried to present a whole thing about how if the gloves are too small, then that is at least reasonable doubt, and so O.J. Simpson is not guilty because there's at least reasonable doubt. Now, forget the fact that for like 10 years later, O.J. Simpson basically admitted that he did it in a book literally called If I Did It. The Chewbacca defense then was, if Chewbacca lives on Endor, you must acquit. Chewbacca is a 7-foot-tall Wookiee, has no business dealing with the Ewoks on Endor. He doesn't live there, doesn't have family there, doesn't, et cetera, et cetera, et cetera. So, like, went into this whole thing about Chewbacca living on Endor. And so if Chewbacca lives on Endor, then Cartman isn't guilty of whatever Cartman was guilty of. Or Chef, it was Chef. Chef isn't guilty of whatever Chef was guilty of. And that was the Chewbacca defense. South Park made it famous. I think Legal Eagle did an episode on it. And it was great. South Park is great. There's a new episode. Did they really finish the season last week, or is there a new episode out today or this week? I mean,
I have no idea.
Okay.
More super chats?
Yeah, Jan Negrey
Sure.
donated 10 Polish zloty and said,
Yay!
On therapy now, we cannot use internet here, gangsta. I guess.
Yeah, I think he's saying that he can't like fully participate because he's not in a place where he
Aw.
can. But he's donating anyway, just to say thank you for doing it.
Yeah, thank you. Yeah, really appreciate it.
Jan's the best. The Gibble donated $2 and said, "Hey Leonard, love the channel, very proud of you."
Thank you. I'm very proud of us too. I love our channel too.
Philip Mosley donated $5 and said, "Keep up the great work. I love listening to you all day while driving my semi." So I guess he drives the truck.
Excellent. We'll have to put out more content for our truck driving audience friends.
Yeah. Spitting Llama donated $5 and said, "Is this a particularly rare thing for a lawyer to be disciplined?"
It's not rare for a lawyer to be disciplined. It is rare for a lawyer to go this far. Usually the discipline happens from one incident or one series of incidents that were then caught as one incident. So maybe a lawyer has been doing something incorrectly or doing something intentionally wrong or stealing money or something and gets caught, and then we have a disciplinary action. Usually a lawyer crosses the line and gets a disciplinary complaint, and then we have a disciplinary action. This lawyer had maybe 10 opportunities to correct this mistake and chose not to fix the problem about 10 times. So it's about doubling down more or less 10 times and lying to the court even when the court was generous and gave you a chance to correct it. That's what's remarkable about this. You don't see this every day because most people know when to stop. Most people know not to push it this far. And by most, I mean like 99.9% of them know better than this. So it's like rubbernecking at a traffic accident. Even when I drive past a traffic accident and I'm yelling under my breath at people, why are you, stop rubbernecking, just drive, we'll all get there faster. I still have to turn my head and look when I get there. That's what this is about. Like, this is not only instructive, it is legal education, it is instructive. It tells people who don't know that lawyers have a duty of honesty, that we have a duty of honesty, and it's a really strict one. It shows people that there is a method to discipline attorneys. It shows people that it happens and how it happens. And like we sort of just answered, it happens frequently when necessary. But it is also a train wreck, and it's also rubbernecking, and it's also fascinating. And in the literal translation of the word, awesome. I am in awe of the court having to exercise these powers over this person.
All right. I have two more super chats for you. Phantom Frag donated again $5 and said, Leonard French, not guilty. I think you may have been referring to a moment earlier.
Not guilty. Yes, I am not guilty.
Yes. Oh.
Everything I say is a lie.
We have Douglas Lewis, who just donated $5 and said, second year law student here, and I just found the channel last week and have been binging your content ever since. Thanks, guys.
Definitely, Douglas. Thank you, and good luck and best wishes in your law career and your second year. Congratulations on passing the first year. That's an accomplishment of itself. About a third to one half of law students don't pass their first year.
And we have somebody trying to begin the Scandinavian tipping wars. The Jasper Augustin, donated 100 Swedish kroner and said, just wanted to say thank you. You've been a huge inspiration to me during my years at law school. Graduation in 4 weeks. Keep rocking, Leonard.
Oh, wow. Graduation during the fall semester. That's awesome. You'll be taking the February bar exam, I hope. And I wish you the best on that. Just keep on keeping on. Don't relax too much until after you're done. And don't push yourself too hard either. That has the opposite effect. So, take care of yourself. Focus on the bar exam. Give it its due, and you'll be fine.
Yeah. So I think we've pretty much gone over everything, right? Is there anything else you wanted to add?
No, that's it. I'm really grateful for everyone who's been here. Do we know how many viewers we had at peak?
At peak, we had about 1,150 viewers.
Holy mackerel, that's one of our best live streams recently.
Yeah,
I'm really happy with that. Well, that's fine. Do you want to read the thank yous for the supporters?
Sure. Yes, absolutely.
I can try to remember. Joe Tyson, Blackleaf, Benjamin Hitov, Steven, I'm going backwards now, Eevi, Kyle Mudrak, SnorreW, Jan Negrey. Who's the third one? There's the second one and third one I've forgotten.
Michael Pearce, Spirit Bear.
Michael Pearce, Spirit Bear. Thank you.
Daniel Perez.
Daniel Perez, Blackleaf, Snorri Wazowski.
And Benjamin Hitov.
Excellent. There's our $50 plus supporters. Thank you so much for your support. We really appreciate it. It's what makes things like this possible. If I didn't have a couple $100 in the account to, spend on gas and originally I thought this was in New York City. It's not. It's in White Plains, so that was a lot easier. A little bit more driving, but a lot less tolls. So we have maybe $50 in tolls or something, and maybe $50 in gas. So maybe $100 trip plus my time.
And thank you also to
really
the $5 plus supporters who are not scrolling on the LED panel, who are not in the crawl on the video, but we love you all
because it's a live stream.
Indeed, it's a live stream. If you missed what we talked about today, go back and watch our pre-stream. We talk about some of the implications, and then we went live right when Leonard came out of the courtroom and talked about what happened. So definitely go back and watch that. This is going to be a VOD available on demand on our channel at any time.
Great. We'll drop another VOD tomorrow. I forget which one it is.
It is, I've forgotten as well.
It's funny because we get through the edit and then we're good at just wiping it right out of our brain. Like everything's done, wipe it out of the brain.
It's the incoherent appeal. It's going to be great.
Right. We had so tomorrow's video is a person who filed a lawyer who filed an incoherent appeals brief, and the judge just lets him have it. So it's kind of like this with Liebowitz, but without the discipline. There's no attorney discipline, but somebody screwed up big time, and you're going to get to see hear all about it and read about it, I guess, if you want.
I believe the judge did say Oh, I'm sorry. I believe the judge actually did say in the thing that he was going to refer them to disciplinary action, so it's going to be
Okay,
interesting.
well then, yeah, wow. All right, well, I'm Leonard French, your favorite copyright attorney. This is Lawful Masses with Leonard French, your favorite legal news channel on YouTube. There are lots of other legal channels on YouTube, and we appreciate you liking and subscribing and clicking the bell on our Lawful Masses legal news channel and legal education channel. So whenever Brandon is ready to take it out, I will bid you goodbye, adieu, farewell, auf Wiedersehen, au revoir, moyen, and adi.
All right. Goodbye, everyone.
Love you all. Bye.